Hello, Paul. Hello, Bianca. Thank you so much for joining us today. We're excited to have you on our panel today to talk about the update on the DOL. We know that that has seized the attention of annuity and insurance agents for quite a little time now, and there's been a pretty substantial update since our last webinar, and we're excited to bring details of that webinar or that update to you folks on this webinar. I'm Jody Goss, president of the producers firm. I've been in the business some 30 years, so this is not our first rodeo of government regulation. The producers firm is an independent marketing organization that serves the independent insurance agent in the annuity space, helps Medicare agents drive more production and loyalty to their clientele. And we feel strongly about delivering financial advice, but we also feel strongly about bringing thought leaders on subject matters to the advisors that work with us. And that's what we have today. We're excited to have a subject matter expert on the DOL fiduciary rule, as well as the insights of our fellow advocate Bianca Noizu, who also has many years of experience. I'm just going to briefly introduce Paul, and then Bianca, I'll have you introduce yourself. So Paul Garofoli, FLMI RICP, he's the regional vice president of individual annuities with the Standard, and he has some 42 years of expertise. Wow. Would you start whenever you were 12, Paul?
You're funny.
He's nicknamed the King of Annuities, and I think you'll see why. He brings tremendous enthusiasm to the topic of annuity. He's a nationally recognized experience. He's known for his entertaining presentations, and we've had the honor of having Paul on stage with us a number of times now. We always appreciate your insights, Paul. Recently, he was elected to the board of directors at the National Association for Fixed Annuities, or NAFA, where he continues to be an advocate of the industry. And we know that organization, Paul, played a key role
in the
update that we're going to talk about, the stay, if you will, on the annuity, the DOL annuity rule. But Bianca, can you share a little bit about yourself? You're the income specialist here at the producers firm. I know you have years of experience and you've seen this before as well.
Absolutely. And I'm not as much fun as Paul, so hopefully I can hold my own during our meeting this morning. So happy to be here. I've been in financial services for over 25 years, worked with the producers firm for the last 5 years. It's been the best 5 years of my career. So just excited for more. I am the day-to-day pinpoint person for agents that are looking for help with cases, looking for information about annuities, help them get the absolute best options for their clients. So I'm in the trenches with you folks day in and day out.
Yes, you are. So as many of you probably already have heard, there's been a stay or a pause, if you will. I think that when people hear that news, they celebrate. They think that they can just relax and take it easy, Paul. I'm sure you probably have heard and seen that. But we feel like that would probably not be the wisest course of action. At the producers firm, we have seen through the years that many attacks like this, and we think this is an opportunity. The stay is an opportunity, or the pause is an opportunity to better prepare ourselves for the next time it happens. And so that's what we're going to really kind of focus in on today. We're going to do this question and answer, interview you, Paul, if you will. I know you do also have a nice formal presentation, but anything to add to your introduction there, Paul? And if not, we'll go ahead and turn it over to you to talk about, what is that fiduciary rule? What was it going to be? And, what is your perspective now?
Yeah, fantastic, Jody. Fantastic, Bianca. Thank you so much for the opportunity here to share some insight on the role. So what was the fiduciary rule? What was the Department of Labor, which was the originator of the fiduciary rule? What were they trying to accomplish? Well, they were trying to expand the scope of fiduciary activities to include insurance-only folks. Typically, we look at people that are registered that might have fiduciary obligations depending upon the scope of their licensure. And in particular, what they focused on was one-time advice for rollovers. Basically, the insurance-only part of the industry had a escape clause, if you will, had a loophole in terms of acting as a fiduciary if you were basically engaging what's called one-time advice, making a rollover recommendation typically from a 401k to an individual annuity. And the reinterpretation of that clause was really the cause for a lot of consternation and a lot of objection, that they were trying to bring in the insurance-only producers by changing the definition of what really fiduciary advice was. And so they were really trying to cover independent agents into a federal best interest or fiduciary standard, in essence, in their view, to level the playing field. And the scope of this was going to be for all qualified plans participants and IRA owners. So anything that is qualified, and when we talk about qualified, we mean recognized by the government for some tax benefit, either tax deferral, either a deduction, either a matching contribution, or in the case of Roth IRAs and Roth 401ks, tax-free income. So that's what qualified is. I mean, qualified is qualified by the government for some special benefit or tax consideration. But what happened? You know, the upside or the downside of this was that I spent a lot of time learning about the DOL rule, Jody, you and Bianca as well, and communicating and helping people be prepared for what they were going to have to do. And then now all that expertise is kind of on the sidelines because it was halted by 2 Texas district courts. There were actually 2 lawsuits filed in objection to the DOL fiduciary rule, and really objecting not to the idea of looking out for clients in the best way possible, but the overreach of the Department of Labor into areas that are typically governed by various states and not authorized by Congress. And so the Federation for Americans for Consumer Choice, the FACC, sued the DOL in one court, and then a coalition of industry partners, the National Association for Fixed Annuities, of which I am on the board of directors, Jody, as you mentioned, yes. NAFA, the National Association for Independent Financial Advisors, IRI, the Institute for Retirement Income, and ACLI, a number of industry organizations came together to sue. And interestingly enough, made a compelling case about that. And we got a stay. Now, what's the significance of a stay? Well, basically, a stay by definition preserves the status quo between the parties, keeping the issue ripe for courts so that they can adjudicate it. So when they have this appeal, it's really to one judge. The Fifth Circuit Court, which is where these lawsuits were filed, has a number of different justices that can come meet together and address the issue at large. But for now, it's been stayed, it's been delayed, it's been put in suspension. But what's interesting is with a stay, there is an assumption that the case is strong enough to win on the merits. So both judges in both cases said, man, you have a really good case here. Jurisprudence precedents, particularly back in 2016 with the version of the rule back then, that really says the DOL cannot overlap or cannot go beyond its boundaries. And so both courts found that, hey, if this ever goes to the larger court, then we think, or the justices think in those 2 respective cases, that the industry will win. So here's the key here. So what happens next? You still have to be vigilant. You still have to keep in mind that there is, a code of conduct still expected in the conduct of your business. Mm-hmm. So what can happen next, Jody and Bianca and audience at large? Well, path one, the DOL decides to appeal the stay. They have 60 days. Now, The ruling came out on or about August 7th or so. So we're about 15 days in to this. They have 60 days to appeal either or both decisions. In this case, the court would come to a decision on the appeal somewhere between 30 to 90 days from the appeal date. If the appeal fails, we would wait another decision on the merits, which could be 6 months to a year after the appeal decision. It really depends on the court's schedule and things like that. So for the foreseeable future, even if the DOL appeals, which some people think will happen, then we still have a window where, in essence, the old rules apply and you're not obligated to act as a fiduciary, don't have that liability. And really, no one objects to looking out after clients. It's the liability. It's the ability to get sued for, petty violations or some misinterpretation of the regulations. So one avenue is the DOL is going to appeal, but that will still take time to come to a resolution. So effectively for 2024, even if they appealed and were ultimately successful, we have deferred or delayed the DOL regulation. Second pathway is they may ask for a more immediate remedy or judgment, a summary judgment. Go, man, these two judges were way off the mark, and we want you to reinstate the rule as is and go ahead and do that. Now, most of the people that I've talked to, and by the way, I'm not a lawyer, but I did watch a lot of Perry Mason as a kid, so I feel like I have some level of expertise.
Right.
So they could do that, but again, the strength of the case and the fact that a variation of this DOL rule was already adjudicated in 2016 indicates that that's not a very likely outcome, that another set of judges in this circuit court are going to go, yeah, man, these two guys in these two cases, boy, they were way off the mark. We're going to just reinstate everything. So we don't think that that is a likely outcome.
Well, it is reassuring that was two judges, not just one, right?
Right, because there were two separate cases filed, basically on similar premises. But in that case, both judges came to a very resolute conclusion that this should be delayed, for a variety of reasons. And then the final outcome or possibility is the DOL doesn't appeal. They go, you know what? We keep been trying to do this, and we cannot do this through our bureaucracy. And really, just on the merits, that is a larger issue that not only affects this Department of Labor regulation, but it's really an issue at large for our democracy, which is the ability for these regulatory agencies to have basically carte blanche ability to interpret, apply, reinterpret, misinterpret some of the regulations put into place by Congress to basically expand their power and oversight. And I've said this earlier that, I'm not this, hey, the swamp and the government's out to get us. I believe, and I've met with some of these regulators, including the person that wrote this new DOL rule. He also wrote the other DOL rule. He keeps trying and trying and trying. And, I believe that their intentions are good. It's just the execution is flawed. There's another element that came into place. There's a case called the Chevron case. And that was a case that basically was interpreted by the judiciary to say, hey, yeah, these regulatory agencies have a lot of liberty in reinterpreting and applying the rules that Congress set aside. Well, that precedent was recently overturned. And justices more recently said, hey, if Congress doesn't authorize you to do a certain thing, and again, this goes beyond just a fiduciary standard, then you're not allowed to make those interpretations. But if Congress says you can do it, then that's all well and good. And I think we all would agree with that. If the law authorizes a regulatory agency to do a certain type of oversight or jurisdiction or rulemaking, then it's all the well good. But if it's just bureaucrats that were never elected that are making these rules and regulations that affect our daily lives, we have objections to that. So there is a possibility. I think the possibility is greater than some think that they might not appeal. And it's just like, okay, we're going to move on to other things, or we're going to work with Congress to get authorization to do what we want to do. And with the political year coming up and the question about who will control the House, the Senate, the presidency, that could resurrect itself. The basic conclusion, Jody and Bianca, is that we're good for now. So it's important to consider that. And what is the status quo? Well, basically, no fiduciary status notice is given. One of the requirements of the regulation is that you would give your client at the point where you engage them in discussion that, hey, I'm going to act as a fiduciary and here's the rules under which I'm governed. You don't have to do that now. Mm-hmm. There is no insurance carrier oversight. And this was kind of the, a question for us and all the carriers, which is that this regulation extended oversight to insurance carriers over independent agents.
Right.
And that was something that really a lot of carriers weren't prepared to do.
Right.
We want our agents that represent our products to do the right thing and represent them in the right way. But that additional oversight was going to create paperwork nightmare, record keeping, all kinds of things. We don't have to worry about that now. So for the most part, insurance-only producers will continue to be subject to the state best interest standard. Right now, Jody and Bianca and the audience at large, there's about 46 states that have what we call the expanded suitability model and best interest model, where you have to take a 4-hour course on annuities in general and a 1-hour course on best interest to continue to sell annuities in a particular state. There's only a handful of states that don't have that requirement now. So now you are subject or continue to be subject to a best interest standard, which is basically fiduciary light, if you will, not quite up to the fiduciary level of responsibility, but still what it says, looking out for the best interest of the client, not being influenced by commissions and disclosing what you're going to get paid. And then ultimately, these exemptions, in order to work with qualified money, the old standard comes into play, both PTE or prohibited transaction exemption 8424 and 2020-02. That 2020-02 primarily deals with people that are registered. So that old exemption still applies there, but basically you can conduct business as you currently are doing right now. So you don't have these additional requirements. Those have been overturned or those have been put on hold until a larger court, if and when a larger court hears the case at large. So that's important. So what is that best interest disclosure that's now in place? And you've seen variations of this. Some carriers have a generic version out there, but basically it's disclosing that, hey, I offer these, here's who I am, here's how I'm licensed, here's what I'm authorized to sell, here's what I get paid.
Right.
And that's it. So you have that. Now, the distinction with this, it's very similar to an 8424 disclosure. There's some additional variations, but basically it's that you're going to act in the best interest within the scope of your license, that you acknowledge that you're getting paid commissions of some sort. And so you have that, and you notify the client of that. So for and this notice now applies across the board in the sale of annuities, whether it is both qualified or non-qualified. So it's important to note that, hey, if your state has this expanded best interest, and it's 46 states, so likely most people listening right now are subject to this state rule, you need to be providing this notice anyway. Most carriers don't want that notice, but we'll notify you that you're obligated to present it and keep it on file. What I want to do as we close, Jody, here is just remind
Paul,
Go ahead.
just so that we had a little clarity there. This is not necessarily a new thing, this form. This is something that has been, so for folks that are listening and you're thinking, oh, is there something new that I have to do?
No.
You've been, if you're in one of those states, you've been doing this right along. So it's not something new.
You
Yeah,
should
it's
be
a couple
doing
years.
this. So let's assume everybody's doing it, but we always also know that some people may have overlooked this, but you now have to integrate this
Right.
in your practice.
And it's part of it's part of an application package.
Yes.
In those states.
And in this, notification and disclosure is one of the points that the attorneys had made that, hey, we're operating under a state regulation that was kind of mandated. There's some different elements, but one of the reasons the last variation of the DOL fiduciary rule got overturned was that states were going to implement this best interest standard in lieu of a fiduciary standard. So that's very important. They go hand in hand.
Paul, I have a question to that end. So obviously 2016 DOL got held back. Now 2024 we're paused, but it seems like a running theme. Do you know how many times that this has been tried these rules have been proposed in the 40 plus years that you've been in the industry? I know I've seen so many changes.
Yes. So by consensus, depending upon who you talk to, this is either the third time or the fourth time that this has been attempted by the Department of Labor. So this goes back to the Obama administration when this was first proposed. It was, either beaten back in a variety of ways, but this is at least the third time that this has occurred, that the Department of Labor, by way of their authorization to regulate pension plans, this actually all emanates, Bianca, from their explicit authorization to regulate pension plans, and then basically their interpretation that as pension plans became more rare and replaced by 401ks, that they basically expanded their oversight to include 401k plans, and then even going forward to IRAs as well. So that's a little bit of the regulatory overreach, but this has been the third or fourth time that this has been attempted. And that's why I say, since they've lost each time, I believe that the next avenue will be to get some type of regulation in place and authorized by Congress that makes it clear that they can impose this type of regulation. So we have to be vigilant that this does not resurrect itself in that way. Now, what I thought I would do is just remind everybody that one of the focus, the key focus, it's been the preamble, it's in all the commentary, is that the DOL was very concerned about 401k rollovers, replacements into annuities, that people might be giving up some of the protections and some of the benefits of 401ks and going to individual annuities by way of a rollover into an annuity IRA out of the 401k. And so I think it's important to reference that there continues to be advantages to doing that. And in particular, when you're looking at and making that recommendation, is there an in-plan annuity option? There, in many cases, there is not. Within the plan, are there guaranteed income options or withdrawals available? Most of the time, it's not. Most 401ks are accumulation vehicles, not distribution vehicles. How about a fixed rate account? Can you find that in there? A lot of times there's not, or even if it is, it's not very attractive. Of course, we have rates right now on fixed vehicles well in excess of 5%, though those are changing. Take advantage of these high rates while you can.
Mm-hmm.
Are there death benefit options? Is there leveraging in that regard? How about accelerated benefit options that now you can find in many annuities? You really have no leveraging or accelerated benefit with in a 401k plan, if you get sick or hurt, with some annuities, you can have that. How about Roth conversion options? Can you do that within the plan? Are there immediate market recovery options, so-called bonuses? That's a nice thing that we have. 5%, 7%, 10%, 15%. I mean, I think I saw 20% out there, either on the income base or even on the accumulation value. But you have that ability to restore value in light of particular losses. And then a consideration on what are the fees being paid within the plan. Sometimes people actually have to pay a fee for the overall 401k wrapper. And then certainly within the different sub-account choices, mutual fund choices, typically found in a 401k, you are paying a fee on those options.
Paul, I was thinking that screen before the slide before, that second one with the guaranteed income, I have had 3 or 4 agents come to me just in the past maybe 2-3 weeks, and they're working with people who have parents that are in their late 90s or even, over 100 years old. So, to be able to prepare for that longevity by some type of guaranteed income, and obviously just with a portion of the retirement funds. But as planners, you got to cover that. You have to take that into consideration. Annuities are the only thing that guarantee that they're not going to run out of that paycheck.
Absolutely.
Hey, Paul, I'll add one more bullet with the standard. Can you convert the asset into a protected income for Medicaid planning?
The answer is yes. That's a great point. And Jody, I know this is a part of the specialty of your firm. Within the standard annuity portfolio, you can convert at any time to what we call a Medicaid compliant payout, or a restricted payout that's non-transferable, non-redeemable, irrevocable. And so in doing so, it might help some people qualify for Medicaid assistance. And right now, we know that 45% of people that live in nursing homes are getting a subsidy from Medicaid. So it's something that needs to be employed in everybody's planning and can be the advantage, particularly with the standard, since we're one of the few companies that allows for that conversion to be considered as an outlet. Going to close with a couple things here. There's a lot of talking about commissions. What I like to say, the virtue of fees versus the vice of commissions. We know that commercial. Do you sell commission-based products? No, we earn a fee. When you do better, we do better. Mm-hmm. What they don't say is when you do worse, we still do good because we still collect the fee. We just get money whether we do something or not. The DOL actually referenced in their regulation that in many instances, this is right from the regulation, in many instances, such as those involving advice on buy and hold strategies, a commission-based model may be more appropriate for the investor rather than advise the investor to enter into an arrangement that requires the payment of ongoing fees without a commensurate need for ongoing advice. So commissions have their place. And in many cases, when you think of buy and hold, what is, Bianca, this is a layup, what is a typical buy and hold insurance product that is available to the agents working with your firm?
I would be looking at fixed annuities, multi-year guarantee annuities, fixed indexed annuities. We run the gamut.
So actually those go hand in hand. The annuity that provides all this protection is certainly a buy and hold product that justifies getting paid a commission. Jody and Bianca, if you allow me to close with this, in terms of, I should say best interest focus now, but in terms of the distinctions of working with us, and of course, working with your agency, you have the ability to deliver the best of the best, all kinds of great products. But why the standard? We've been A-rated or better since 1928. Got a documented renewal history. We have extended maturity on all our products, so clients will not outlive their annuity with the standard. We have 100% nursing home rider in all instances, at all issue ages, even all the way up to age 93. We issue all the way up to age 93. We allow for joint owners and joint annuitants. We have flexible death benefit options. We have that anytime annuitization, which can be just a regular payout or a restricted Medicaid compliant payout, Jody, that you referenced. We've got the best death benefit rider in the business, and we have participation rate guarantees. So beyond just this great knowledge that we're providing you today, consider the Standard as a great annuity outlet, both on the fixed side and the fixed index side.
Yeah, your death benefit rider is just amazing.
Yeah,
I agree.
Concur, Paul. The Standard is a great annuity carrier to work with.
Agreed.
Yeah.
So with that, I don't know if anybody has any questions, Jody, in the comment section, but other than that,
looking for that. Bianca, how is the producer's firm helping agents really prepare for perhaps a time when we might have to face this rule again?
Well, I think, Jody, I mean, you and I, we have over 60 years experience working with annuities, and we are also fiduciaries. So we deeply understand what is needed. We've already built it into the process that we have, that we make available to the agents that work with us. We've navigated numerous changes, in the last couple of decades. Our process really helps an insurance agent learn how to get to know your client, not only to uncover more assets and make the best possible recommendation, but also to be able to substantiate their recommendation to governing authorities. I think too, one of my favorite aspects is our case design team. So if an agent is working with us and they have a case, they reach out to us and we scour the marketplace for the best option for that client. So there is that, that due diligence that's done that can be proven, and you can keep in your files that you're not just writing the same product, time in and time out. And I think that's what regulators want to see. The other thing I think too is our back office support. Once a client does complete an application, if a rep so chooses, they can share that client application with us before they submit it to the insurance company. So we will do just a quick suitability review, look it over. Is there any red flags that our executive team sees? And then we can have a nice phone conversation with that advisor and just make sure that when that business hits the insurance carrier, when that business hits the Standard, that it flies right through suitability. The client account is set up and again, we have this documented process that has been just exceptional, not only for closing business, but also for protecting us as advisors and the recommendations that we give. And that's our customer rounding process, Jody.
Yeah, we've had tremendous success with this process that we've developed through the years. I'm just going to go ahead and share our website that supports the process, customerrounding.com. It is a password protected site. But if you navigate over there, if you are licensed with the producer's firm, you'll get the password right there on the front. Listen to some of the advisors that we work with and the successes that they've had, that this process that takes you right through each and every appointment. And this is really designed to be compliant with a fiduciary and a best interest standard. So we look forward to supporting and helping you. Paul, we don't have any questions. You must have done a fantastic job in covering that material. Thank you so much. That's why they call you the Annuity King.
You got it, brother.
And we always have fun.
Yes.
Talking with you, Paul.
Bianca, thank you for joining today as well. And enjoy the rest of your week. Thank you so much.
Be good.